Hi there, good morning, good afternoon, good evening, whatever time it is. As always, happy whatever day it is. Welcome to Left Side of the Aisle. I'm your host. My name is Larry Erickson. It has been since I was born. It still is and will be for a while, I hope. I'm your host, and for the next half hour or so, I'm going to be talking about things that I think you should know about and maybe do something about or be concerned about. As always, any reactions to the show, send them to me directly. The email address is whoviating, WHOVIATING at AOL.com. And if you didn't catch that, go to my website, Lotus Surviving a Dark Time. You can get the email address from there, or you can leave a comment there. If you do send me email, as always, be a little patient about getting an answer because I'm a little slow with email, and be sure to include something in the subject line that makes it clear this is not spam. All right, with that, we're going to start, as I always like to start, try to start every week with a bit of good news. In this case, in fact, the good news consists of common sense coming out of an unexpected place, the war on drugs, which actually is a topic I want to talk about sometime because the war on drugs has been a colossal failure. And that by throwing everything from marijuana to methamphetamines to heroin into one pile labeled drugs, as if they were all exactly the same, presented exactly the same dangers, the war on drugs has actually probably created some of the very drug use that it intended to stop by creating mistrust about the statements made about those drugs that really do present serious dangers. Anyway, but the good news. Back in 2008, Massachusetts voters approved a ballot measure to decriminalize marijuana, small possessions of marijuana. Anything less than an ounce was no longer a criminal offense. It was a civil offense with a maximum $100 fine. Because of that, in 2011, the state's Supreme Judicial Court ruled that the smell of burnt marijuana was not enough of a basis for police to suspect criminal activity. Since possession of less than an ounce of marijuana was a civil offense and the smell alone did not give police enough reason to assume that there was a criminal amount of marijuana present, there was no legal basis to use the smell to treat the situation as if it involved criminality. Okay, here's the good news. On July 9th, the Supreme Judicial Court has ruled that police can't use the smell of raw, that is unburnt marijuana, as a pretext for searching a car. Quoting the court, the strength of a smell is, at best, a dubious means for reliably detecting the presence of a criminal amount of marijuana, the court very reasonably concluded. The smell of unburnt marijuana points only to the presence of some marijuana, not necessarily a criminal amount. Which means, again, the cops can't treat a civil offense as if it were a criminal one just because the horror word drugs is invoked. And I say that is good news. And as a quick footnote to this, by the way, 23 states and the District of Columbia now approve medical marijuana, and Florida is one step away from joining the ranks. All right, going on from there to one of our regular weekly features, the Clown Award. Now, a couple of people, actually, I have to say, have been retired from contention for the Clown Award, which, as always, is given for meritorious stupidity. Because if I left them in, they would just dominate the rankings, okay, and there wouldn't be any room for anybody else. One of these people is Supreme Court Justice Antonin Scalia, of whom I will just say that I can't understand why some supposedly knowledgeable people refer to him as this great legal mind. I think it would be more accurate to replace the words great legal with never. Another is Representative Louis Gohmert of Texas, the man who puts the Gomer in Gohmert, who can be counted on to say something stupid on a pretty regular basis. But there is another one who was in retirement that I had to take out of retirement because, well, you'll see why. So this week, the winner of the Big Red Nose is the man with the world's most perfect initials, Bill O'Reilly. On his July 14th show, after citing a recent Harris poll saying that 46% of Americans who are not retired report living paycheck to paycheck, he proceeded to tell those people what they could do about it. He started by saying that you should have at least $25,000 on hand that you can access, money you can immediately access in case you get fired or some financial crisis hits your family. He then proceeded to tell people how they could amass such an amount, and I'm quoting him. First of all, never waste money, ever. That trinket, you don't need it. Then look at your life. See what your vices are. See what you overdo and cut back. Then go to websites like Groupon. Get discounts on stuff that you have to buy. Never pay full price. Also, every time you have loose change in your pocket, put it in a big jar. That'll add up fast. Pay your cable bill someday. But most important is what my father drummed into my head. Every dollar you make, save 10 cents. No excuses. All right, first bear in mind that this is the multimillionaire who recently called income equality bull and a fabricated political thing. And then let's go through what he said. All right, first, every dollar you spend should be on necessities. No frills, no trinkets, nothing just for fun, nothing to make your life brighter or more colorful. Apparently, you're not rich enough to deserve any of that. Oh, and your vices? Don't have any. By the way, speaking of trinkets and vices, I wonder what Bill O'Reilly's loofah bill is. But getting back to what he said, Groupon and the rest are these deal-of-the-day sites, which means if you don't happen to need that day's deal, so you had to go pay full price for a loaf of bread and some cereal, well, apparently according to Bill O'Reilly, you paid full price, and somehow that was your fault, you wasteful loser. Oh, and a jar for spare change. Oh, yeah, that'll mount up so fast that someday it will pay 1 month's cable bill. Which also means, by the way, that having cable is apparently a necessity. It's not a waste or a trinket or any other sort of unnecessary expense that you could do without. It's a necessity because if you don't have cable, you can't watch Bill O'Reilly. But here it is, the putrid poetry of the pontificating pinhead. Every dollar you make, save 10 cents, no excuses. You're to save 10% of your total income, no excuses. Now remember, this is being addressed to people he has already described as living paycheck to paycheck, which means by definition, they don't have much beyond that. Saving 10% of that current income is, in effect, a 10% cut in the amount of money you have now to pay those current bills. How are people who are already living paycheck to paycheck supposed to do that? The utter cluelessness, the utter disconnect between this bozo and the life he presumes to judge and the people he does judge as just needing a little more self-discipline because if you're poor or you're struggling, it's your own fault. You're either lazy or spendthrift or both. The utter disconnect between the self-important nitwit and the people he condescends to advise. Well, I was actually going to say it's stunning, but when you think about it, actually it's only exactly what you should expect. Which is why Bill O'Reilly is and always will be a clown's clown. And we are taking a break. And we are back, and we're going straight to our other regular weekly feature. This is the Outrage of the Week. And for this, I'm actually going back to something I've talked about before. Actually, it's the Hobby Lobby decision, but I'm going to look at a very different aspect of this because amid all the discussion that got raised about the effect on contraceptive care and rights to abortion and to protection and so on, there was something else that was largely lost in the shuffle, and as a result, it did not get the kind of attention I think it deserved. In Hobby Lobby, the Supreme Court found as a practical matter that a profit-seeking corporation, a commercial business, can have a religious belief and rights of conscience. It had never found this before. This is a dramatic and far-reaching expansion of the ill-founded and constitution-twisting notion of corporate personhood. The idea that in some ways, and now in an increasing number of ways, a corporation is just like a living, breathing human being, a person with the same sort of rights. What Citizens United did for the idea of corporate freedom of speech, Hobby Lobby did for corporate freedom of religion. That the foul five, the maleficent majority of the Supreme Court, knew what it was doing here is evident in the way that they try, the extent that they went to try to play down the meaning. No big deal, nothing to see here, move along, nothing new or radical about creating new rights for corporations. In fact, in his majority opinion, Sam Alito wrote that, quoting, "A corporation is simply a form of organization used by human beings to achieve desired ends." That is a declaration so utterly at odds with both the real world and the law as to brand it a deliberate lie meant to conceal the impact of the ruling. It is, in fact, as one commentator put it, a radical reimagining of both First Amendment and corporate law. Corporations are not just another form of organization used by human beings to achieve desired ends. Corporations are different from other forms of organization. They are intended to be different. They are designed to be different. That is their whole point, to be different in the way which they are different. In his dissent to Citizens United, John Paul Stevens wrote that corporate personhood, quote, often serves as a useful legal fiction, but they, that is corporations, are not themselves members of we the people by whom and for whom our Constitution was established. It is important, it is vital for us to remember that corporations are legal fictions. They are legal constructs. They are creatures of law that have no existence apart from their definition under such law. Corporations do not actually exist in the physical world. There's no building you can point to and say, that's the corporation. Maybe that's where the corporation is headquartered. Maybe that's the place where it does a lot of its business. But that's not the corporation. There's no person you can point to and say, that's the corporation. No, you may be an officer of the corporation, maybe a shareholder, you may be an employee, but you are not the corporation. Even those cases where a single person incorporates themselves, you can't point to that person and say that's the corporation, because the whole idea is that the corporation exists apart from that person. The corporation itself is a creation of the state, which again, by design, exists apart from the people who make it up. Corporations are intended, they provide for those involved with them protection against certain types of risk. That is their whole point. And it is altogether possible for a corporation to exist without any facilities, officers, employees, agents, income, debts, property, to exist solely on paper. It would be utterly incapable of action, but legally it would still exist. On the other hand, unincorporated groups, organizations, association, clubs, that is, actual organized groups of people, whether they're political or otherwise, whether they're ad hoc or long-term, doesn't matter. They exist only as the aggregate of their members. No members, no group. It doesn't exist. If any unincorporated organization owns any property, there are actual people on the hook for related debts. If there's a lawsuit, it's against people, not against some disembodied legal formality. Corporations, by their design, by their nature, by their intent, are different, and it is inane to suggest otherwise. And that's the point here. Corporations are, again, designed to protect persons involved from certain points of risk. That is, by incorporating, those people gain special protections, and that corporation occupies a special status, one not available to others. It's entirely reasonable, logical, and I say constitutional, to expect that in return for that special status, that those corporations, not the individuals in them, but the corporations, face certain restrictions on what they can do in the public arena as compared to what actual living, breathing human beings can do. But even so, courts have held that corporations can assert some, but not all, they say, of the constitutional rights of individuals, and the courts have, in fact, over time strained to make distinctions about what rights are purely personal and so unavailable to corporations and which are not. But even that idea, the idea that corporations have any rights beyond guarantees of equal protection and due process, including the right to sue and to own and use property in accordance with law, the idea that corporations have any rights beyond that may rest on a, to use an old phrase, a foundation of stubble and straw. The modern idea of corporate rights, that is of corporate personhood, comes from an 1886 Supreme Court decision called Santa Clara County v. Southern Pacific Railroad. Except it doesn't. The phrase corporations are persons, the entire foundation for the doctrine that corporations are legal persons, does not appear anywhere in the ruling. Rather, it's a summary of the arguments written that were presented in the case, which was written after the case by a court reporter. And those summaries are not legally binding. They are strictly advisory. What the court actually said in the case was that the 14th Amendment guarantees of due process and equal protection apply to corporations such as were parties in that suit. They did not say, corporations are people, my friend. In fact, for the first 100+ years of our history, that wasn't the law. For example, in a case decided in 1819, Chief Justice John Marshall said, quoting, "A corporation is an artificial being, invisible, intangible, and existing only in contemplation of law. Being the mere creature of law, it possesses only those properties which the charter of its creation confers upon it." That is, the rights of a corporation depend upon the object for which it was created. Which is why, by the way, profit-oriented corporations can be and have been treated differently from specifically religious institutions and nonprofits, having to do with the object for which they were created, or at least they were treated differently. Because, of course, that John Marshall decision, that was before corporations, just like the Velveteen Rabbit, became real. Although, in this case, the love involved was that of money and power. Still, for that reason, for that very reason, it could be argued that the Marshall decision is more likely, simply because it was closer to the time, that it's more likely that the Marshall decision represented the intents of the framers vis-a-vis corporations of the political process, which should have been of concern to those strict constructionists who are always looking for the original intent in anything, but of course it wasn't. I say that we are entirely within our rights and authorities as a free people to define the rights, the protections, and authorities of corporations in whatever way we choose, including opposing whatever limitations we care to place on them, limited only by those baseline guarantees which have again existed from the beginning. That is, which they were again equal protection, due process, access to the courts, and the right to own and use property. Beyond that, well, the deal is we offer the privileges, we offer the protections that corporations provide for their participants, so we get to set the conditions under which they are available. You don't want the restrictions, you don't incorporate. But the Supreme Court continues to go in the opposite direction, to provide corporations and the rich elite that run them more power, more authority, and fewer restrictions, giving them by judicial fiat more and more of the rights previously to be held by what is an increasingly anachronistic phrase, human rights. And now it is declared that perhaps the most human of rights, the most distinctive of human qualities, the right of conscience, they say it also describes corporations. That corporations can have consciences that entirely apart from the actions of their directors, because remember the point of a corporation is to be separate from the people who are part of it. Corporations can pray. They can express devotion to a god. The corporations can have and do have their own emotional and spiritual existence. As we continue to strip away what is human in the service of the corporate state. And that is an outrage. All right, there's a quick footnote to that. I suspect rulings such as these, not the Hobby Lobby, because that occurred after this poll was taken, but decisions such as been seen by the Supreme Court recently, is a good part of the reason that public confidence in the Supreme Court has dropped 7 percentage points in the last 2 years and is now at a record low. Just 30% of the public has a great deal or quite a lot of trust in the court. Now, confidence in all three branches of the federal government has been declining, but confidence in the Supreme Court had remained relatively steady between 42% and 50% approval since 1991 until, interestingly, right after Sam Alito joined the court in 2006, replacing the relatively moderate Sandra Day O'Connor, after which the court took its dramatic right turn and its approval rating has not reached the 40% level since. All right, last thing. This actually follows on with what I've been talking about. The connection may not seem clear, but if you think about it, it's there. I mentioned a couple of weeks ago that just after days after the city of Seattle voted to raise the city's minimum wage to $15 an hour over the next several years, a group of corporations had filed suit to overturn the law. As I said at the time, some of the suit's arguments are laughably frivolous, such as the claim that it violates the corporation's free speech rights because if they have to pay more in wages, they won't have as much money to advertise. But more importantly, this suit seeks to re-energize two long-rejected legal theories: class legislation and liberty of contract. Now, class legislation was defined as legislation that picks out a group of people for special benefits or special burdens without adequate public justification. Now, that sounds reasonable, but the problem is any law can be made discriminatory if a judge looks hard enough. To illustrate this, consider an infamous case from 1904, Lochner, the People v. Lochner. The state of New York had passed a law limiting the number of hours that bakery workers could be required to work to 10 a day and 60 a week. A bakery owner named Joseph Lochner was convicted of violating the law by having one of his employees exceed the 60-hour limit, and he appealed his conviction. He lost in lower courts, but there one dissenting judge claimed that a law prohibiting bakery owners from overworking their workers was unconstitutional class legislation because it only applied to the, and I'm quoting here, small fraction of the community who happened to conduct bakeries or confectionery establishments. That is, a law regulating bakeries was unconstitutional because it only applied to bakeries. The case ultimately went to the Supreme Court, where it became known as Lochner v. State of New York. The Supreme Court there struck down the New York law as unconstitutional, but not on the basis of class legislation, but rather on the basis of liberty of contract. The idea that if the workers agreed to work those punishing hours by the fact of accepting the job, that the courts would not interfere with that freedom. Using that same argument, later Supreme Court decisions struck down minimum wage laws because that took away your freedom to work for less, and laws protecting the rights of workers to form unions because that took away your freedom to agree to deal with the bosses all by yourself. The point here is that both these doctrines, class legislation and liberty of contract, had over the course of the 20th century become regarded as invalid and improper. In fact, the Lochner case has been taught in law schools now as an example of how courts should not act. Alongside such abominations as Plessy v. Ferguson, which is the one that found that racial segregation based on separate but equal was constitutional, and Dred Scott v. Sanford, which found that African Americans could not be U.S. citizens, but were, in fact, quote, beings of an inferior order, so far inferior that they had no rights which the white man was bound to respect, unquote. But now, at this point, some high-powered legal talent. You got the lead litigator in the Seattle minimum wage case is Paul Clement, a former U.S. Solicitor General under George Bush and an all-around right-wing go-to guy. There's some high-powered legal talent which seems to think that with the Supreme Court apparently willing to go out of its way to say that corporations are just like living beings, that this is the time to try to bring these legal notions back, to strike with arguments that, if they were adopted by the courts, would essentially invalidate the 20th century, because any government regulation or restriction of business would be subject to being found unconstitutional. Every minimum wage law, every law protecting the rights of workers to organize, every environmental regulation, every law about overtime, every health and safety law, every consumer protection law, every law barring discrimination in hiring and promotions, every law barring discrimination in public accommodation, all of them and more. And don't think this is a one-off. George Will, the man all right-wingers turn to when they want to imagine they have any intellectual authority, and the man who once wrote that back to 1900 is a serviceable summation of the conservatives' goal, and yes, that is a quote, George Will said not long ago that the Lochner case was correctly decided by the Supreme Court based on our individual possession of inalienable rights, including apparently our right to choose to be so desperate that we'll submit to being overworked, underpaid, and exploited until we're no longer of use and can be dumped by the side of the road. Meanwhile, right-wing legal theorist David Bernstein wrote a whole book recently devoted to, in the words of the title, Rehabilitating Lochner. Bringing back the legal theories of class legislation and liberty of contract, theories used in past years to strike down health and safety laws and the rights of workers, these theories, talking about bringing back these theories are continuing threads in right-wing legal circles. And Paul Clement has decided, he's no fool, Paul Clement has decided that now is the time to bring them back into court, with his briefs to the Supreme Court probably already in preparation. Make no mistake about it, George Will said it, back to 1900. At the time he wrote that, which is about 10 years ago, he probably thought of it as a dream. Now, there are certainly those who can see it on the horizon. The right wing in this country is looking to undo the social progress of the entire 20th century. And if we don't pay attention and fight back, they might just do it. All right, that's actually going to be it for this week. I'm not going to try to get in anything else just now. I will tell you that we've got some cool stuff coming up. I know I've talked about that science show. Yes, it is coming. It will happen. Believe me, I don't lie. What's the old line about? I know me and I don't lie, so that must be true. But that is coming, and we're going to see you next week. I'm going to have some, I hope, other interesting stuff for you next week. A couple of topics that I've been meaning to talk about and haven't had time for. I'm also thinking about the fact that I haven't talked about Iraq and this caliphate nonsense. But I will say very quickly, since I still got time to get this in, something I do want to say about Iraq. Remember how all the pundits were saying that how the ISIS was sweeping through and Baghdad was going to fall and the army was collapsing and the government was collapsing. Remember, here is where you heard somebody say that they'd gone through all the Sunni areas. Now they were coming to areas where there were more Shiites and where there were Shiite militias defending their own turf, and they're going to find it a lot harder going from now on. You tell me which of those predictions has proven to be the more accurate in the last couple of weeks. Anyway, that's it for this week. We're going to get out of here. In the meantime, you have the best week you possibly can. Peace.